Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, can my prenuptial agreement include a provision about infidelity? Can it penalize my partner for cheating on me?
So, the provision that you're referring to specifically is known as a bad boy clause or a bad girl clause, and it is an example of a lifestyle clause. And I've actually done an entire video on lifestyle clauses and the common pitfalls or issues with enforceability of these types of clauses. So, if you have any questions about these non monetary provisions that you may want to include in your agreement, I encourage you to take a look at that video because it does address some of the common pitfalls, as I said, with including these types of provisions. A bad boy clause or a bad girl clause is generally a provision that provides some kind of penalty, often a financial penalty, for a party who has engaged in an act of infidelity as defined by the agreement itself. Now, it can be unilateral or it can be bilateral, meaning it can apply to one of the spouses or it can apply to both of the spouses. And the way it's commonly structured is if there has been a determination that one of the parties has engaged in some act of infidelity, they may be subject to having to pay more alimony than they otherwise would, or may need to give up certain rights to assets in the event that it's the moneyed spouse. Or if it's the less moneyed spouse, perhaps then they're waiving or forfeiting their right to alimony, or they're going to get less alimony, as an example, or they may forfeit their rights to certain assets as a result of engaging in this act of infidelity. Either way, it's important for the parties to understand that it's critical that they consult with an attorney that's licensed in their state prior to including this type of provision in their agreement. The enforceability of these lifestyle provisions generally, but specifically the bad boy and bad girl clauses, really varies from state to state. Some states may determine that they are violations of public policy or otherwise just not enforceable. And to the extent that they're still included, it could jeopardize the validity or the enforceability of your entire contract. So really, it's important for the parties to understand the consequences of including one of these lifestyle provisions in their agreement prior to actually doing so. Now, there are different reasons why parties may want to enter into an agreement that has a bad boy or a bad girl clause. One common reason is that the parties want to clearly define what their expectations are for their marriage or their relationship and what their values are. And they want to ensure it in writing so that both of them are on the same page as far as what their values and expectations are. Now, parties also include these types of provisions in their contracts because they're essentially trying to circumvent or contract around their state law. Now, some states are no-fault divorce states, meaning the court does not take into consideration the misconduct of either of the parties when determining who's entitled to spousal support or how much in spousal support the party's entitled to, or distributing assets and debts. And the parties may say, this isn't an appropriate scheme of law for us. We do want to take into consideration any kind of marital misconduct to the extent that it somehow damaged our relationship or led to the breakdown of the marriage. Now, in Connecticut, the parties do have the right to file for divorce for fault, even though we do have no fault divorce on the books. So, to the extent that they meet certain elements or statutory grounds, a party can file for divorce. But it's very common that the parties will file for no fault, in part because even if you file for no fault divorce in Connecticut, you still are allowed to introduce the reason for the breakdown of the marriage so that the court can consider it when determining alimony or spousal support and the division of assets. So in a way, it's I hate to say a loophole, but another way to introduce this evidence even though you filed for no fault. It does not mean that the court will absolutely consider it or that the court is guaranteed to give it a certain amount of weight, but you can introduce it and the court will evaluate whether or not it should be a factor in determining alimony or the distribution of assets. Now, to the extent that parties, as I said, want to circumvent their state law, A, they should be familiar with what the applicable law is in their state regarding the consequences of any kind of marital misconduct. And B, they should understand any consequences of including this lifestyle provision in their agreement to the extent that the court determines it may be unenforceable. One common reason why states or courts routinely determine that these types of provisions are unenforceable is because they're often too vague or subjective for the court to really even interpret the meaning of the parties and enforce in any kind of meaningful way. So, for example, it's insufficient to simply just have a provision that states that if a party engages in an act of marital misconduct or an act of infidelity, that there will be XYZ financial circumstances, because the parties may define infidelity or adultery or misconduct in different ways. One spouse may say it's not adultery unless you've engaged in sexual intercourse, while the other spouse may feel that just sending a flirtatious text message is an act of adultery or infidelity. And then you get into this rabbit hole of, well, how do you define flirtatious? One spouse may think something's flirtatious and the other may not. And so unless the agreement really clearly defines what constitutes an act of adultery or infidelity, the court is really left guessing as to how it could possibly enforce such a vague provision. And often, if the provision is so vague and ambiguous, the court can't enforce it, and it will determine that the provision is unenforceable, which really defeats the purpose of including it in the first place. Another common issue that these provisions run into is that they don't define what the standard of proof or what the burden of proof is going to be for having to essentially verify that one party has engaged in an act of infidelity. So does the party need to admit to it? Do you need a certain kind of documentation to prove it in the event that it's a contested allegation? The parties really need to be very clear and very concise in their agreement as to how this provision can possibly be enforced. Without that level of detail, it's going to be very difficult for a court to actually interpret the provision in any kind of meaningful way and therefore enforce it. And of course, discussing these different types of issues with your significant other and kind of contemplating all the different ways that the provision can be triggered is certainly not a discussion that many people have the appetite to engage in. So it can potentially lead to problems even without memorializing it in writing. But really the critical thing here for people to understand is that you could jeopardize the enforceability of your entire agreement to the extent that your state does not allow these types of provisions, or this provision specifically, this bad boy, bad girl clause, to be included in your agreement. So it's critical to consult with an attorney who's licensed to practice in your state prior to negotiating and including one of these provisions in your specific agreement.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.